So I think the participants have started to stabilize. So welcome. I'm Jose Alvarez, Faculty Director of the U.S. Asia Law Institute here at NYU. And this is our weekly speaker event. So let me introduce our speakers. So Congyan Cai is a professor of international law at Fudan University School of Law. And he joined Fudan only in 2020, having spent the previous 15 years at Xiamen University School of Law, where he has taught and writes about international legal theory, foreign relations law, international investment law, and Chinese international legal policies and practice. He has published in the most widely known journals in the field, including the American Journal of International Law, the European Journal of International Law, the Chinese Journal of International Law, and the Chinese Journal of Comparative Law. So far, he's published 2 books, The Rise of China in International Law, which is the subject of today's discussion, and The BRICS in the New International Legal Order on Investment, Reformers or Disruptors, that is coming from Brill in 2020. He's at work on 2 additional books that are forthcoming, The Contribution of the UN Security Council to the Law of Peace and War, with a number of co-authors from Cambridge University Press, and another Cambridge University Press book, The Cambridge Handbook of China and International Law, with a huge number of authors. He was a Fulbright scholar and a global research scholar here at NYU. And in fact, we take pride in the fact that the chapter that we distributed to you from the book at least joined to the RSVP for this event, which is chapter 14 from the book on international law in Chinese courts, originated with work here at NYU while he was a global scholar. It ended up being a widely read piece in the American Journal of International Law, and then was adapted and updated for purposes of the book that we're addressing. He's been a visiting professor at Columbia Law School, as well as Humboldt University School of Law. The Kobe University School of Law has seen him on 4 distinct visiting times, and he's also been an adjunct professor at City University of Hong Kong School of Law. Among the major research projects, other than the 2 forthcoming books that I've indicated, is an article that's now being considered at the Leiden Journal of International Law on the rise of China and the strategy of universality of international law. And if we have time, of course, I may ask him about what he's writing in that piece. He's also considering a new book on socialist states and international law, looking backwards and forwards. So now I turn it over to Professor Cai. You have to unmute yourself, and you have 15, 20 minutes to describe the book and focus on anything, not counting on the fact that many people on this call will not have been lucky enough to read it, who have read it.
Okay. Okay, thank you, dear Jose, dear Kathleen, and dear juries, whom I'm not sure is at present or not today. Thank you all for inviting me as a weekly speaker. I'm very happy that I come back to the NYU Law School in such a unique way at the difficult times of the COVID-19. From 2011 to 2012, with the great support from Professors Jose and Professor Kingsbury, I was honored to stay at the NYU School of Law as a Fulbright scholar and global research fellows. I, in particular, remember that Professor Jerry Cohen had lunch with me at the restaurant nearby the NYU Law Schools. Actually, it's when I conduct research concerning how new great powers would influence international legal order during my stay at NYU. I also consider the possibility of writing a book of China's and international laws. At that time, I was aware that a more powerful China, which has its own characteristics in terms of its politics, economics, civilizations, as well as ideologies, must bring about many effect on international legal orders. And this potential effect need to be addressed carefully for other countries and China itself. Actually, during my writing of my book of the right of China in international laws, we witnessed many great change. Some of them are within our expectation, but some of them are not. We see the relationship between China and the US has deteriorated. The US identified China as a strategic competitor. The US launched trade war and technology war against China, and it appeared that the US considered a mini NATO in the Asia and Pacific area to contain China. We see that US, together with Japan and EU and perhaps other Western states, consider new trade rules within and outside the WTO, which obviously target China. In particular, ideology appear to come to the forefront of struggles between China and the US. The US leaders more and more refer to communist China rather than China, highlighting Chinese socialist ideologies. We can also see China reject South China Sea arbitral award and increase its military presence in at the South China Seas. This arise great concern among some states as to China's policies in relation to the legal order at sea, and more generally, the whole international laws. On the other hand, we also see that China and EU cooperate to support WTO, which lead to the multi-party entering appellate arbitration agreement after the appellate body ceded to operate as a result of the US blocking the appointment of new members. Currently, we also see that the world is seriously plagued by COVID-19, which outbroke first in China and then spread across the world as a global pandemic. Some states blame that China failed to duly report it to the WHOs and crack it down as soon as possible. Whereas for the part of WHAs, these institutions fail to duly exercise its authority. Of course, it comes as no surprise that China firmly refused these accusations. In the past several decades, China always stated that it developed international relations in accordance with the UN Charter, and in particular, the 5 principles of peaceful coexisting. More recently, China leaders say that China is a staunch defender and builder of international rule of law. It should be noted that China's policies and practice in international law win the support and good appraisal from some states and international organizations. However, some other countries, especially major Western powers, argue that China has failed to honor its international commitment and more generally reshape international legal order in negative ways. For instance, Joseph Borrell, High Representative of the European Union for Foreign Affairs and Security Policies, and Vice President of the European Commission, in his recent paper, openly argued that China pursued a selective multilateralism. Tom Kinsberg, in his paper publishing in the American Journal of International this year, proposed that China, together with Russia, etc., pursues authoritarian international laws. In the view of Ginsburg, this authoritarian international law constitutes a threat on liberal international legal orders. In these areas, which according to Chinese leaders is unprecedented in the past centuries, people may be more concerned with the relevance of international law in the international society. So today I would like to raise several issues for participants open to debate. I would not like to give my definite conclusion of this issue. First, how to understand China's selective approach to international laws. Some observers suggest that China cleverly take an approach of selective adaptation, thereby seeking to minimize the maximize the benefit and to minimize the risk arising from the relevant international regimes. The theories of the selective adaptations actually is often used to explain why China has signed some treaties but reject others, why China is more willing to honor some treaties than others, and why China comply with certain regime better than others. As noted above, Joseph Borrell from the EU's noted China take a selective multilateralism. He, in particular, argued that China's aim is to transform the international order into a selective multilateralism, multilateral citizen with Chinese characteristics, in which economic and social rights would take precedence over political and civil rights. Legally speaking, China should not be blamed by its approach of selective adaptation or, in particular, selective multilateralism, because any state has its right to decide which treaty they want to be bound, except use Kogan. Actually, other countries like United States also take the selective approach to international law. However, great power, including China, have larger responsibility to enhance the universalities of international laws, which represent the fundamental value in the international community as a whole. For instance, human rights conventions. In this sense, it is wise for China, for me, it is wise for China to ratify the international covenants on civil and political rights after more than 20 years of signature in 1998. Because this is in a sharp contrast with the international covenants on economic, social, and cultural rights, which China signed in 1997 and soon ratified in 2001. Second, how to understand China's changing normative agenda in international laws. For a long period, China is a taker international law. Therefore, the compliance with the law has been the priorities of Chinese international legal policies. China spared no effort in seeking to convince the Western world that China is a good citizen in terms of law compliance, even though the Western powers complain that China should have done more. In addition, the Western world has traditionally paid much attention to the implications of China's law compliance in China, but little to its spillover effect abroad. More recently, China sees a largest entrepreneurships. President Xi Jinping pointed out that with the increase in global challenge and constant change in the international balance of powers, there is a growing demand for strengthening global governance and transforming the global governance system. So China must seize the opportunity and take actions. And thereby, in recent years, China seeks to propose Chinese within China's solutions to global affairs. It remains to be seen to what extent China would achieve its non-entrepreneurship. However, the U.S. is alert about China's entrepreneurship and seek to discover China's role in international lawmaking. For instance, in seeking the proof of the TPA in early 2015, the President Obama stated that my top priority as a president is making sure that more hardworking Americans have a chance to get ahead. Right now, China wants to write the rules for commerce in Asia. If it succeeds, our competitors will be free to ignore basic environmental and labor standards. And it is believed that the U.S. negotiate and sign the TPP in order to treat out the regional comprehensive economic partnership (RCEP), in which China play a leading role, and China's BRI. However, the problem is that for me, whether it is justified for the U.S. and other Western powers continue to dominate the process of international law making. Third, how to understand the relevance of China's socialism in international laws. Socialism does not represent ideologies in China only. It indeed has sweeping effect on almost all aspects of China's political frameworks, economic regimes, and social life. Today, the US and other states are especially concerned with the effect of China's socialism on the international legal order on trade. According to the US, in order to develop a socialist market economic, China's government and the Chinese Communist Party direct and channel economic actor to make government's planning and permit market force to operate only to the extent that such activities accord with their objective of national economic and industries policy, which run against the open market-oriented policies underlying the multilateral trade system. However, according to the principle of sovereignty, which is enshrined in the UN Charter and the international law principle, which approved by the UN General Assemblies in 1970s, any state has the right to decide which regimes and institutions it adopt at the domestic level. Nevertheless, in the era of globalizations, domestic regimes and institutions may indeed produce tremendous spillover effect abroad. Therefore, it is really a great challenge for China to balance the protection of its sovereignties in terms of natural governments and with the international concerns arising from the potential spillover effect of China's national governance. Fourth, how to address concern that international law in existence is not totally effective in managing China's behavior. It seems that some states consider international laws in existence is not effective enough in regulating China's belief. For instance, in his latest review of China's WTO compliance, the USTR announced that it is long in supporting China's exception to WTOs. And the problem is how to address the deficiency of the international laws. According to China's, in the China-US trade wars, China governments argue that some WTO members, including US, has some concern about the new rules. According to China's, this new rule should be negotiated. They should not unilaterally impose. However, what we see is that US more and more reliant on its national laws to address the deficiencies of international law, rather than propose new agenda of negotiations. Of course, we also see that U.S. together with EU and Japan see to consider more stronger regulations on industries, subsidies, technology transfers, policies, and market-oriented conditions. Fifth, what kind of international laws we need in the interest of all states and all generations. In the 2016, David Kennedy published a very interesting book of the World of Struggle. Kennedy argued that international laws has failed to protect sovereignty, enhance democracies, and reduce policy across the world. He appealed for the alternative to the current philosophies and methodologies of global governance. So I think when we talking about China's load or influence in the current international legal order, we should reconsider whether the current international legal orders is justified to maintain, or it should be transformed in the interest not only China's, not only the U.S., but in the interest of all the nations, strong or the weak, wealthy and poor. So I agree with arguments proposed by the Barry Buzan that he said China's peaceful rise cannot be accomplished by China's alone, but only by China's and the rest of international society working together to create necessary conditions. So my very short conclusion is that China should change, but other countries should also change accordingly. Thank you. This is my brief introduction. Thank you.
Thank you very much, Professor Cai, for that. You mentioned along the way that you hoped Jerry Cohen was listening. Well, he is, and congratulates you on the book and the chapter that we distributed. But in Jerry's way, and I'll give him the floor before I ask you. He's very specific. Jerry is. He doesn't like vague generalities, so he goes straight to the heart of it. So he's asking you two questions. One is, does contemporary international law bar the use of force by a state to settle territorial disputes with its neighbors? That's the first one. Does contemporary international law bar use of force to settle territorial disputes? And second, sort of a natural follow-on, why doesn't China agree to peaceful means of third-party dispute settlement when it comes to territorial disputes? It could be arbitration, could be the ICJ, could be ITLOS, you name it. But China seems to resist. So can you answer those questions from Jerry?
Okay. Let me answer the second question first. I think of course, China support the third parties, the adjudications of international disputes. For example, China accept the jurisdiction of the WTOs and investment disputes, but I think it is quite difficult for China to accept the third-party adjudications of the territories disputes. First of all, I think any states has the right to decide which means of the settlements of these disputes. This is a general argument. But the thing is, as far as China, I think because I think maybe there are two major reasons. First, the territorial dispute between China and its neighboring country, for example, India, is very historically complicated. It's really complicated. I think neither China's or nor India's is confident to bring the territory dispute to any third parties adjudication. This maybe is concern the evidence. You know, in some sense, the territorial disputes between China and its neighboring disputes are brought about the foremost colonized the countries. So I think this is not only involve legal issue, but also involve some sentiments of the of Chinese peoples and Indian peoples. So this is, I think, the second reason that neither China's governments not I think its neighboring country, for example, the Indians, to bring the territorial dispute to the third parties adjudications. And so I think it's, the territorial dispute is quite different from others dispute, for example, the trade dispute, investment disputes, and the first question, I think that's generally speaking, according to the UN charters, any state is not allowed to resort to force to settle internet dispute according to the territorial disputes. I think China's abide by and submits the general principle, but I admit that in realities, in the histories and in the realities, many countries disregard of the UN charters. This does not mean that China's would disregard of the UN charters, provision of non-use of the force in the settlements of the territorial dispute. And actually, of course, China have some military confrontations with the Indians. In 1962 and in these years there are also some military confrontations in the areas of the boundary between the two countries. But I think is that these military confrontations does not reach the use of force. And both China and India, I think, are self-contained. And I don't know whether jury is concerned with whether China use of force some days to unify the Taiwan's. I think it's the territorial dispute between the China mainland and Taiwan is different from the territorial dispute between China and India, because this does not concern the territorial dispute between two countries. This is issues of the dispute between within ununified country. Yes, according to the China's anti-section laws, China's government does not abandon the right to resort to force to unify the Taiwan's. I think this is if someday China use the force to unify Taiwan, this is I think a non-international military conflict. I think it's but anyways, I think it's we could not use the UN Charter to regulate the potential military confrontation between China's mainland and Taiwan. I think it's because they are these disputes is different from that from the dispute between China's and India's.
Okay, so just a short follow-on. I think the connection between the two Jerry questions is quite clear because of the charter, because the UN Charter says in Article 2.4, you don't use or threaten force, right? And then it says in Article 33, you should resolve your disputes by any of the following peaceful means, including mediation and conciliation. So the fact that it blocks you from threatening force and tells you to settle it with anything other than force is why the two questions are connected. Now, I totally understand your distinction between the disputes between two nation states and mainland China and Taiwan. But I think Jerry's question was also discussing the many, many disputes around the South China Sea that are not so complicated, that have been settled peacefully around the world, so that in the area that I know best, Latin America, many territorial disputes in Latin American, between Latin American states have been settled by the ICJ. And so, and some of them are, yes, complicated historically, but the question of whether or not something is a rock or an island, the boundary disputes that threaten the possible use of force, very much so, in the South China Sea, are very much the stuff of Article 33 of the UN Charter. And I think Jerry is asking, why shouldn't those be subject to dispute settlement? Peaceful.
I think the currently I think it is hard to say China's impose or exercise military threat in the South China Seas. Oh, yes, in my introduction, I say that in recent years, China's got increased military presence in the South China Seas. But the first thing, but I think this is very important, which I think many people, especially those in the Western world, ignore that. Why China's increased military presence? Before the 2012, the China's military force or presence in South China Seas is very small. Actually, for me, my argument is that the major reason is that the Hillary Clinton's rebalance Asia's policies, and more and more U.S. military force move from the Europe to the East Asia, and these militaries are exercised in the eyes of China government impose great threats. That's why I think China has to increase militaries and presence in South China Seas, and China's more military presence in the China Seas make the South China Sea neighboring countries more nervous, and this further made the Philippines to initiate South China Sea arbitration. So I think we should expand the whole stories. So I think who may be responsible for today's South China Sea situations. Maybe China should be responsible, partly responsible for this. But I should say that maybe it's also U.S. should be responsible for this. And and I would like to ask the questions, the journalists, the questions in in terms of the South China Seas, why China's I understand his question is that why China refused to accept South China Sea arbitral award. For me, I think that if we are positive international lawyers, China should accept and honor the South China Seas arbitral awards. But from another angle, that is the legitimacy. Those I think the many of you have raised the critique of the South China Seas arbitral awards, which were written by the many Chinese international lawyers. I'm not an expert of the law of seas, but maybe one thing is sure that the South China Sea arbitration is flawed. Is somewhat. This is not legal. I mean, it's the positive, but at least in terms of legitimacy, right? And many Chinese people, including Chinese international lawyers, said the South China Sea arbitration is flawed in terms of legitimacy.
Right.
But for me, maybe it's the second reason. Maybe it's more important that involved Chinese nationalism. Because let me tell you that when I was a primary school student, from my textbook, I was told that the Sparkly Islands belong to China's territories. So I cannot imagine if China's government agreed to honor, agreed to enforce South China Sea's award. I must say, if China's government or China's Communist Party agreed to do so, the Chinese Communist Party must lose any legitimacy of its rulings in China. So I think it's, of course, I certainly support to peacefully resolve the disputes in the South China Seas, but I really think it is not a good idea for Philippines to initiate arbitration procedure against China because anyone, if he knows know about Chinese nationalism or Chinese civilizations, who knows? China's government, in particular, China Communist Party, would not be brave to accept any those funding in favor of China's. And I think from the beginning of the South China Sea's procedure, I think this is very certain. I think so. This is not about whether China's participate in the South China Sea proceedings. I think if China's participate in the South China Sea's arbitrations, I think that does not matter at all. The question is that China's China's government. I can't imagine the China government would accept any funding.
Okay, so let's go on because I do and I totally understand that the law of the sea is not your specialty, but so I want to raise other issues because your book is a rich source of them, and one of them is the fact that one of the reasons the book has been relatively well received in the West is because I detect that your audience, your intended readership, is in the West. That is, you make constant references to Western authors. Right now, you even mentioned Tom Ginsburg on authoritarian international law. You made reference to Thea Roberts and comparative international law. So the book seems to be written with a Western audience in mind. And the message seems to be, don't be afraid of the rise of China. As China rises, it will comply with international law. Am I wrong that that's the audience? And you mentioned that your book is not available either in English or in Chinese in China. So am I wrong about the audience? And why do you think the book is not available in your home country?
I think I don't know why. It's because although I'm an international law from China, but I'm not nationalist. So I but maybe it's I write something those criticize the Chinese policies, but I don't know why my book is not allowed into the China. But maybe this is temporary, because in the early these years, myself purchased some books. It's no problem, but I don't know. 2 months ago, my book is not allowed import. I don't know why. Because I think it's yes, I could criticize some of Chinese international legal policies and practice. But as you know, the some Western readers said my book is a book of party line, defending Chinese international.
Yes, and that's about to be published, and that's Simon Chesterman, who who is the dean of National University in Singapore, published a book review of your book, and along those lines that yes, this is the Chinese government line in book form, which struck me as interesting given what you've said about the book not being available. So, what is your answer to Simon? Is your book really critical of the Communist Party or China? What do you say to that?
Simon is a very nice man, but of course he says my book is party lines a book. But what I'm interested in is that in his book reviews, he's talk little about my book. He talked much about Chinese international legal policies and practice. He's very critical Chinese international legal practice and practice. So I don't know whether this is a framework of the book reviews. I have read some book review for English book. I did not write in this manner, but maybe there is a question that is that from the Simon's book reviews, more and more Western peoples, including international lawyers, tend to be more critical of China's policies at international levels and national levels. I think this is a major impressions I get from his book reviews. Yeah. So I do not know. So ask Kings why you did not talk about or review much about my book or my argument, but talk about China's international legal policies.
So that raises the question, as you mentioned in your book, and Thea Roberts and our students have read comparative international law, her idea that if you actually look at how each of us teaches international law in the West versus China and other places, there is no single international law. It turns out we pretend to have universal rules, but we each teach it from a very different, sometimes country perspective. Do you agree that there really is no single international law, but that we should engage in comparative international law? And that, for example, when you teach international law in Xiamen, as you did for many years, it probably doesn't look like what I teach international law in NYU. Do you agree with that?
I think maybe it is not wise to give yes or no. I think of course when we talk about the UN Charter, we should admit that there is universal treaties because there is only UN Charter, right, binding all the member states. But we should admit we have different interpretations of the UN Charter's provisions, right? Because I think this is understandable. Let me take example of the human rights. For example, China's got signed the International Covenants of the civil and political rights, even though it has not yet ratified it, but China agrees that the human rights should be universal. That means all nations should be respectful for human rights. But this does not mean China and other countries have the same conception of the human rights. For example, in the Western world, human right is the individual rights center, right? But in China, the human rights is understood within the relationship, among different individuals. So this is not China's. I mean, the communist China tell me to understand in this way. This is inherited from China's civilization. Before China signed the ICCPR, we have the conception of the human rights. It is matter. So I think the problem is that how we reach a consensus on the conception of the singles treaty provisions or the legal terms.
Okay. So another thing that you're quite candid about in the chapter 14 on Chinese courts and international law is you say, and you're quite candid, that the Chinese Communist Party basically controls everything, including the courts. You say that, and that's different from at least what Westerners say their courts are about. So, right, Westerners say, look, courts are not mouthpieces for a particular political party, and certainly not mouthpieces for the single political party, assuming that there's only one. So what is the role then of Chinese courts, not just with respect to international law? If they're just a tool for the Communist Party, what do they do?
I think yes. I said in my book that the Chinese Communist Party is you can see in every place of the Chinese lives, including the cost. But I think this does not mean that the Communist parties in any times intervene the judicial's independence, because in China there is only ruling party, Chinese Communist Party. So that means whether or not the state is run good or bad should be bear by the Chinese Communist Party. This means if the parties intervene with the cause and make the people realize there is no justice from the cause, it further damage the legitimacy of the Chinese Communist Party. So you can see that in the past several decades, in particular, since the President Xi Jinping takes his powers, the CPP, the Chinese Communist Party, take very strong measure to track down the judicial corruptions. But the problem is that in individual cases, and some local communist parties indeed interviews the handlings of individual cases. But this is, I think, not the policies of Communist Party. I think it's the Communist parties, what Communist Party to do in the core is to ensure is the political leadership and ideologies, social ideologies. I don't think the Communist parties want to interview the judicial administration, because the almost all the party leaders have no knowledge of the cost, the judicial administrations. It actually rely on the judge. So I think even though there are many literatures talking about the damage of the judicial independence by the interviews from the CPP, I don't think so. I don't think so.
Okay. So I just want to encourage those who are listening. I know there's over 50 folks listening in. Shortly, I'll be turning to the Q&A box. So if you want to put in and type your question, and I'll just tee up just one or two more while we do that. So in your book, you mentioned the Beijing Consensus, and you've talked about the fact that that few people look at what is China's goal when it goes abroad. That is, when it extends aid, for instance. So you believe there is such a thing as the Beijing Consensus. Could you say more about what that is? And when China goes abroad, what is it looking for?
The Beijing Consensus it was not created, was not coined by Chinese governments or Chinese scholars. It was coined by, I think, it's American expert. But I think but I think to large extent it's right to capture the characteristic of China's development patterns. I think for a long period, the patterns it represents little threat or little the concern for the outside world, including US. But I be as the China's the growth. China's powers grows, especially more and more Chinese companies investing abroad. These patterns has problem. for example, in China, for a long time, we have the low level of labor protections, environmental protections, and the problem is that if the host states, is the host state, for example, those in the African countries also just have the low level of the labor protection and environmental protection. The problem that means more Chinese companies invest abroad. They made more. They made they may brought about the more infringement of the labor rights, or bring about more political environmental pollutions. But if you look at Chinese companies in the South Africa, I think for example the Argentinas, because there is very strong labor protections and the environmental protections. So I think the Chinese company have to abide by the local regulations. So I don't think that the Beijing Consensus would bring about substantial negative effect on the other country as China's Chinese company go abroad. There's, for example, if Chinese company invested in the United States, there is no problems of the Beijing Consensus, right? But I should emphasize that China's actually make many measures. I mean, in China, requiring Chinese companies should not only abide by the local regulation, but also abide by Chinese regulation, which apply to Chinese company abroad. Then this is unique kind of the actual territories of Chinese law.
So I guess that connects a bit to what you say, which is, and I want you to say more if you can, before we turn to the questions, on the goals of the Chinese Belt and Road Initiative, right? You are an expert in international investment law, for instance, but I am not entirely clear how the BRI meshes with the international investment regime, with China's tradition of being what I would call a rule taker when it comes to investment law, that basically adheres to, for example, Western models of bilateral investment treaties. And within a few years, you see China emulating a lot of the guarantees for investors and a lot of the protections for states, frankly, that Western states have put in their BITs. The BRI doesn't map on very nicely, I think, with existing bits. Or maybe I'm not understanding it, but it seems to be creating an alternative to investor-state dispute settlement, such as a commercial court based in China, or perhaps an arbitration system with Chinese characteristics that is different from that of the World Bank. Can you say more about the role of international law, investment law, in, say, the BRI, and what the BRI is about?
Actually, I don't know why those so many Western people are concerned with the BI. I mean, from legal perspective, yes. From the economic perspective, BI is a great initiative or strategy for China. But from the legal perspective, I don't know why those both Chinese international lawyers and Western international lawyers attach so much attention to BRI. You know, BRI is there is no regime for BRIs. The BRI is supported by so many legal regime. For example, the BIT or the FTAs and etc. But I agree with you that China through the BRI would propose a new modality of the settlements of economic dispute, not only state to state investment dispute, but also the commercial dispute. I think it's for me is the more important from the legal perspective of the BRI is that China's seek to establish itself as a hub of the international economic disputes through the BI's through the BI. For example, as you just says that the China's Supreme People's Court established international commercial courts or international commercial tribunals. And let me tell you that just 2 days ago, there is a news organization of international settlements of arbitration and mediations, just established in Beijing. This is a private organizations, not those intergovernmental organization. So I think it's if this will happen between Chinese investor with the host state, I don't think how this investment dispute can be transformed into dispute between Chinese investor and the local investor in the host states. Actually, initially, as far as I know, when the China Supreme Court consider the establishment of the China's international commercial tribunals, this tribunal is authorized to handle the state and investor disputes. But finally, they find that it is not feasible. So today is the China's international commercial tribunal only accept or only handle the disputes between individuals. So I think it's I don't think it's the BIs has any substantial influence on the investment treaty regime or the trade regime. Maybe it's at the beginning of the BI, China government has the ambitious in this regard, but finally, right. I think, yeah.
Right. So in your book, you do suggest that even though, putting the BRI aside, that even though China has mostly been a rule taker in the investment regime, you foresee a future with the rise of China where even the investment regime, the bilateral investment treaties, the investor-state dispute settlement, will develop Chinese characteristics. That is, that China will also change that regime. What changes do you think China would like to make in the investment regime?
I think as I say, China is a taker of the investment regime. Let me take examples. In the bid signed China with India in 2006. And this bid includes the provision of the indirect exploration. But do you know how this provision is provided? this provision provide, among others, the legitimate expectations refer to reasonable and distinguished expectation. But as you know, the reasonable or reasonable expectation is very fabulous in United States, right? That is because there's numerous cases, but in China, nobody's know the means of these things.
No, that's a perfect example, right? Because the indirect expropriation language that you're referring to is taken directly from a leading U.S. Supreme Court case that our students read, whether they take property law or constitutional law, which is Penn Central, dealing with a Penn building not too many blocks from here. So the three-part analysis from that 2006 is straight out of the U.S. Supreme Court, which is a perfect example, as you say, of taking U.S. initiative and incorporating into a Chinese treaty.
Yeah. So actually, I many years ago I have an opportunity to participate a discussion of the China-U.S. BIT negotiations. I suggest that China government should not accept any the provisions borrowed from the American domestic law, because we have no idea also what these terms or provision means. Of course, I think it is less likely, or if not impossible, for China to negotiate BIT with the United States. So let me go to directly what China's think of the investment regime. I think that China's compared with the United States, at least China's would like to make the BITs more flexible. For example, even those as well as I know, those at the end of this year, it is expected that China's and the EU will conclude their bid, and in this bid, China would commit to the pre-establishments natural treatments. But I think in other bid, for example, China's which China signed with the some other developing countries, which I think China's government would be flexible in terms of natural treatment. So I think this does. I mean, it does not mean China's propose a new input in bid. Maybe it just means China's conclude the bid those with flexible manners. I think maybe this is just China's what China can they pursue.
So we have now our little discussion has generated a lot of questions. So let's try to keep the responses brief so we can get through more of these. This connects to what you just said. You mentioned norm entrepreneurship by China doing something original with respect to distinct international regimes. And the questioner is, when China engages in norm entrepreneurship, how different is it than norm entrepreneurship by other countries? Is there characteristics that make China's norm entrepreneurship when it comes to international law truly original?
I think as you know, actually it's about I think it's the 2012 after the President Xi Jinping took his powers, and China's government began to pursue the new strategies or norms entrepreneurship, because China's government from its experience in the WTOs realized that China should no longer act as a taker of international law, because as I just said about the China-India's bit, if China does not pursue its non-entrepreneurship, it just take the international laws. So when China implement the treaties, you may find it could not understand the treaty provisions, and it further means that China fail to honor its international commitment. But this is not intentional of China's government. This is because China's government could not understand, correctly understand the means of the some treaty provisions. But at this stage, I don't think that China's has achieved much in its non-entrepreneurships. I think because the President Xi Jinping said China would increase non-entrepreneurship is one thing, but whether it can be achieved is another thing. It depends on many factors. For example, in recent years, China proposed many proposal, many resolution in WTOs, but I do not find this China's proposal have been accepted by many others. That means that, take example of the investments facilitation in the WTOs. China is a sponsor, is one of the sponsors of the investment facilitation friend in WTOs. And I compare Chinese proposal of the investment facilitation with with that proposition proposed submitted by the Brazil. I find the Brazil's proposal is more convincing, more feasible than Chinese proposal. So I think maybe it need long time for China to achieve its non-entrepreneurships for a long time, I think.
Okay, so here's a challenging question by one of our attendees. Does China pursue rule of law or rule by law?
I think it's maybe it's most legal theorists in the Western world say what China pursues is the ruled by law, not rule of law. To some extent, I agree that the China according to the socialist theory of laws, the law is an only instrument for a ruling party to govern the states. So, but I should say that in other countries, law is also instrumental, right? So I don't think there is the totally conflict between the rule of laws and ruled by law. But of course, they are different, especially at the domestic levels. And I agree with that. What China pursue is ruled by law, not rule of law. Even though it does not mean that there is no rule of law at all. But I should say that at the international levels, maybe there is a little difference between the rule of law and ruled by law, right? Because even the European countries advocate international rule of laws, but I rarely find American government talk about international rule of laws. It always says international laws, but it is interesting that Chinese leaders in recent years talk much about the international legal law, international rule of laws. So I don't think whether the Chinese leader really know the means of international rule of law. Maybe it's you want to send a positive signal to the Western world that China's governments abide by the international laws. But I think at the international levels, there is no international rule of laws, but ruled by laws. Actually, if we read some documents adopted by the UN General Assemblies, this document just suggests that the states are encouraged to sign or to enter into the human rights conventions and accept international adjudications, but these documents say little about how international adjudication should be operated. How, for example, international justice courts, or in particular ad hoc tribunal, how these institutions are well operated to ensure rule of laws. So if these international institutions, especially international courts, cannot guarantee the international laws, international rule of laws, how they ensure the states, including China and United States, to submit dispute to handle? Yeah, that's.
So we're running low on time, so keep your answers short if you can, but I do want to give a lot of others here a question. You emphasized China's tradition of what you call passivism as important to its interpretation of international law. And the questioner is asking a question about that. That is, what is China's tradition of peace? That is, of pacifism. How does it comport with military confrontations that we now see, not just in the South China Sea? So I guess it's asking you, what is the history of China tell us about the likelihood that it will, in fact, adhere to peaceful resolution of disputes, especially when it resists sending things other than trade and investment disputes to third-party arbitration?
Yeah, yes, indeed. In the mainstream of Chinese civilizations, which refer to the Confucians and Taoisms, there is a pacifism in Chinese civilizations. So I think that you can find many Chinese governmental documents which says we have the traditional pacifism. That's right, I think. But the problem is that the tradition or the civilizations maybe maybe not as important as we think. I remember the international lawyers, Professor Ananda from India, which also has a long tradition of the pacifism. Professor Ananda said, civilizations is not is not important as we expect. When we talk about the civilization or tradition, to some extent, we talk about the interest. So I agree that China has a tradition of pacifism, but I don't think this is very important for today China to handle the international disputes.
So I think this may be our last question, but you mentioned that Chinese courts have not been favorable to the extraterritorial application of somebody else's law, that's not consistent with international law. And of course, the questioner is saying, well, what about Article 38 of the new national security law of Hong Kong that purports to punish conduct outside of China and Hong Kong, even if it's perfectly legal to say some things in the United States or in Europe? It sounds like what I say about Hong Kong here in the US can subject me to criminal prosecution back in China or in Hong Kong. How do you, how is that consistent with international law, especially on extraterritoriality?
Yes, I think this is a big problem. Of course, you know, like the United States, China's governments in recent years adopted more and more laws with provision of extraterritorialities, including the Hong Kong laws, national security laws in Hong Kong. But I think it is that maybe it is not the right time to draw any definite conclusion in this matter. We need time. We should keep close eyes to how the Hong Kong's SAR enforce this provision. If this provision is applied in too broad manners, I think it may infringe international investment law, because of course China has you know the protective jurisdiction under the international law, but there is legal limit on this jurisdiction. So I think I don't know whether these provisions would be applied in coming months or coming years in Hong Kong. But what I want to say is that let's wait and see.
Okay.
Actually, you know, in China, there is the different opinion as to this provision. Not all Chinese lawyers, including international lawyers, support this provision. But for me, I think we need time. We need time to observe how it will be observed, how it will be applied.
Okay, well, I'm willing. We have a tradition on our end to finish on time, so we'll conclude here. But I can't resist saying that you'll have to forgive me if I don't have too much patience on time, because the next time I visit China and I'm arrested for saying something about Hong Kong, maybe the time is not something that I want to give them. So it is something of a challenge for academic freedom.
Yes.
To have something like that hanging over all of our heads. But thank you very much for being so candid and for your book, which our students have read in the Globalization and International Law in East Asia class. Next year, perhaps we'll have you present the book or your new one on socialist states, perhaps. But in any case, I'm thanking so many of us who participated, and forgive many of you who wrote questions. We addressed little portions of it here and there, but as always, we ran out of time. Thank you, Professor, for your participation.
Okay, thank you all, and I wish you health is in New Year's. It is a difficult times. I hope everything is will be well. Okay, thank you.
Thank you. Bye bye.
Thank you. Bye bye.